Hello, everyone. Welcome to Court with Krissy. It's time for another collection. I need to clear some clips. From Not My Needle to Not My Pants, followed by Their First Time, and ending with Not Their First Time. Let's watch as these judges lay down the law. I hope you like it. Court with Krissy is now in session.
Okay, Miss Miller, are you able to hear me?
Yes, sir.
Okay, we'll go back on the record and People versus Miller. And Mr. Seeger, you had further communications with Ms. Miller yesterday.
Yes, Your Honor. Your Honor, it's my understanding that Ms. Miller would consider a plea to an edit count 2 of possession of analogs, which is a 2-year felony. In exchange, count 1 and the habitual offender force notice would be dismissed. Additionally, Your Honor, the people have agreed to a sentencing cap of a county time sentencing cap, Your Honor, which.
All right, Mr. Ziegler, is that a correct statement of the plea offer in this case?
It is, Your Honor.
And Mr. Seeger, are we taking the factual basis to the methamphetamine?
Yes, Your Honor.
Ms. Miller, were you able to hear all of that?
Yes, sir.
Okay, and I know this morning you indicated that you wanted to go forward with trial. It sounds like this might be a little bit different of an agreement. Have you reconsidered that?
Yes, sir.
Did you want to enter into that plea agreement here today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Miller, are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty that you could face for possession of analogs is up to 2 years?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
So the date that I have, this happened a while ago, it looks like, back on January 15th of 2021. Is that the correct date to the best of your recollection?
Yes, sir.
On that date, were you present here in Kalkaska County?
Yes, sir.
On that date, while you were here in Kalkaska County, did you have possession of some methamphetamine?
No, sir. I had possession of the used syringe.
Sorry, that was muffled. Can you repeat that?
I had possession, or it was found in my coat, a used syringe.
So there was a used syringe in your coat?
Right, but my coat wasn't on me when they arrested me.
Okay, where was your coat at?
Inside in the house or whatever. Like I come out the house and the people whose house it was or the cop said that he wanted my coat or whatever, that he had to have it for whatever reason, and they went back in and got it for him and brought him out the coat that they have where they found the syringe in.
Okay, did that syringe have some methamphetamine residue on it?
I'm not sure. The tests say yes, so
Okay, it tested positive for methamphetamine?
yes.
Do you have any reason to doubt the accuracy of that test?
I'm not sure to answer that, so no, I guess not.
Okay. And are you saying that somebody else put that in your coat pocket?
A possibility, but I'm not sure. I just want this over with. So
Oh, well, was it yours? I mean, did you put it in your coat pocket or did somebody else do it without your knowledge?
to my recollection, I can't per se that I put it in my coat pocket. Just things being as they were then, I highly doubt it, but I don't know. I was unwanted where I was at that time, and the homeowners who I was dating their son, they called the cops because I had a child support warrant at the time.
Your Honor, may I assist with the factual basis?
Sure.
So, Ms. Miller, on or about 1/15 of 2021, you were in Kilkasket County, correct?
Yes,
All right. And at some point in time, you came into contact with law enforcement, correct?
yes,
And at some point in time, they found in a jacket that belonged to you, methamphetamine, correct?
no, they found a used syringe.
All right, and that used
There's
syringe
no
had.
drugs found.
Yes, Ms. Miller. All right, Ms. Miller, I don't care if you have a trial or not, and I've explained this to you enough times. So you're either taking a plea or you're not. It's your choice. It's not mine. I'm not going to force you to do anything. The syringe was either yours or it wasn't. And you can either have a trial or you can accept a plea. But the court has already been gracious and given us another opportunity. So the syringe was either
accepting
yours, or it wasn't.
I'm just
So I
not
don't
gonna
care what-
lie and bend what
All
actually
right, then
happened.
let's have a trial then. Let's have a trial
I
then.
said I'm
Ms.
taking
Miller,
it. I'm just not gonna lie, but to get up to that point to be able to take this plea, I'm not gonna. That's asinine.
Okay, well, but you can't establish a factual basis, Ms. Miller, if you can't establish that it was yours. If it wasn't yours, well, then it wasn't yours. If it was yours, well, then it was yours. We can't have our cake and eat it too. Did you put it in your jacket at any point in time, or are you disputing, or I think you said that you don't recall, it could have been yours, it may not have been yours? Is that your statement?
Right, I don't recall.
All right, so, but
So I'm
during
just-
that time
yeah,
period, had you been using drugs during that time period? Is it likely that the syringe with the residue was yours?
It was found in my possession, so therefore it would be mine.
Okay, so the syringe that was found in your possession was in fact yours, is that correct?
Sure.
Okay, no further questions.
Mr. Ziegler?
Your Honor, I think the testimony is established that the coat was hers, she was under arrest, she had control of that syringe. She seems to say she has a lack of memory about whether she put it there, or whether someone else put it there. But she's established that it was in her possession and control. It was a coat that belonged to her. I think there's a sufficient factual basis to establish that there's possession, at least constructive possession. So I would ask the court to accept the plea.
All right. I mean, I have to agree with Mr. Seeger here. I mean, the statute requires that she knowingly or intentionally possess the syringe. So Miss Miller, here's the thing, and Mr. Seeger's tried to explain this as well. I can't find you guilty of this charge unless you knowingly or intentionally possess that syringe. Do you understand that?
Right. I guess I'm, I don't know,
Mr.
I'm
Seeger,
taking fault for
listen
it.
to me. Listen to me for a second. Mr. Seeger is correct. So you either knew that syringe was in your pocket or you put it there, and or you had no idea and it was just found there. So which of those options is the truth in this case?
I have no idea if it was mine or if anybody else put it there. I
All
can't.
right. Well, I'm not going to accept your. I'm not
If
going to
there is,
accept.
then I'm gonna.
I'm not going to
I
accept.
just don't remember. At that time, I had a drug problem. I can't say that I did or didn't do it, but will say yeah. I was just around other people at that time that also did those things. So, I don't know. But I was in the wrong for being around those people.
Okay, so you can't be convicted of a crime for being around the wrong people. So if you didn't know that it was there or you didn't put it there, I can't find you guilty. And the only other option we have is to go to trial. So I'm going to give you one more opportunity. Did you know it was there or did you put it there?
No,
Very
I didn't
simple
know it was
question,
there. No,
and
I
it
didn't- I
only
didn't put it
requires a
there
yes or no
intentionally,
answer.
But yeah, I'm claiming it as mine because it was my coat.
Okay, again, I'm going to ask you one more time, and it's a very simple yes or no question. Did you know it was there or did you put it there? Yes or no?
Yes.
All right, thank you. The court finds now there is an adequate factual basis. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Ziegler, or I'm sorry, Mr. Seeger.
Yes, sir.
Ms. Miller, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You're going to be contacted by somebody from probation regarding a pre-sentence report. It's important that you follow through with that contact so that we can have that completed. The sentencing hearing will be in person. So once you receive the notice of date and time of that hearing, you will need to be here in the courtroom in Kalkaska County. I'd also recommend that you stay in touch with Mr. Seeger, your attorney, prior to that hearing. That's all for today, and you're free to disconnect at this time.
Your Honor, can we get her
Yes.
phone number, please?
She's already gone, but Mr. Seeger has that.
Okay,
Forward, Ms. Wagner.
thanks.
We will go on the record in the matters 21 CM 150, 24 CF 78, State of Wisconsin versus Billy Benjamin. The state appears through District Attorney James Renicky in person. We have Nicholas White, Defense Counsel in person. Ms. Benjamin appears in person in custody. We're set here today in this matter for a preliminary hearing. Mr. Renicky, you may call your first witness.
Call Trooper Lind.
Trooper Lynn, please come forward, raise your right hand, and then have a seat over here in the witness stand.
Do you swear that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
You may begin.
Trooper, could you tell us your full name and spell your last name for the record, please?
Zachary Lind, Lind,
And how are you employed?
as a trooper with the Wisconsin State Patrol.
Approximately how long have you been employed in law enforcement?
2 years, 11 months.
Have you had training and education to be a law enforcement officer?
I have.
Does that include on-the-job training?
It did.
Directing your attention to March 9th of 2024 at approximately 6:30 in the evening, were you on duty?
I was.
Could you tell the court where you were and what your duties were at that time?
I was working a highway criminal interdiction detail in Burnett County. I was alongside State Trunk Highway 77 in the town of Swiss.
Okay, were you in a full uniform and driving a marked squad car?
I was.
What, if anything, did you observe relative to an eastbound Ford Escape?
Yes, I observed an eastbound Ford Escape with loud exhaust. I initiated a traffic stop on this vehicle.
Okay. Did it also have a taped over rear passenger side window?
It did.
Were you working with any other troopers or officers at the time?
Yes, Trooper Ann Workman was also present with me.
Okay. Were both of you present at the stop of the Ford Escape?
Yes, we were.
How did you approach the vehicle, and how, if any way, did Trooper Workman approach the vehicle?
Trooper Workman made a driver's side approach while I made a passenger side approach.
And what, if anything, did you observe when you approached the vehicle?
I observed 4 occupants, a female driver, a female front seat passenger, a female rear seat passenger, and a juvenile female passenger also in the rear seat.
When you were making a passenger side approach and you were close to the vehicle, what, if anything, about the vehicle did you notice or observe?
Trooper Workman observed that the odor of marijuana was coming from the vehicle.
Okay, and did she report that to you?
She did.
Okay. And when you make an automobile stop in general, do you generally try to identify the occupants of the vehicle?
Yes,
And did you do so on this occasion?
I did.
And did you try to identify the front seat passenger?
I did.
And how did you identify the front seat passenger?
She gave a verbal ID of Chastity Benjamin.
Okay. And did she actually give you a first name, a middle initial, and a last name?
That's correct, and a date of birth.
Okay. And ultimately, what happened in your interactions with this person?
We determined that this was a false identification.
How did you determine that?
I later asked the defendant if I could search her person. She consented to this, and I found a Mille Lacs tribal ID card in her rear left pant pocket, which identified her as Billy Benjamin.
Okay. Did that also identify her with a first name, middle initial, and last name and date of birth?
It did.
And did it also have a photo ID on it?
It did.
And did the photo match the individual that you were speaking to?
It did.
What, if anything, did that individual tell you about whether or not those were her pants?
She stated that those were not her pants and that she had borrowed them to put them on today. I asked who she borrowed them from, and she stated her uncle. I asked her if her and her uncle wear the same size pants, and then she stated that they were her uncle's roommate's pants, who is also her cousin.
Okay. And then at some point, did Trooper Workman tell you that she recognized her from prior contacts?
She did. I showed her the ID card, and she then recognized her as Billie Jean Benjamin from previous contacts when Trooper Workman was employed in the Pine County Jail.
Okay. Did you have further discussion about the subject, and did she admit to giving you a false name because she had outstanding warrants?
She did. I asked her if she had warrants, and that was why she was lying to us, and she stated, yeah.
Okay. Did she make any representations to you or show you any written documents about her having received consent from the person whose identity that she did use?
She did not.
And to this date, we're now in December, has anybody given you any documents or made any statements to you or any information relative to this other person giving the defendant consent to use her name?
No.
Okay. Did the Wisconsin State Patrol Communication Center confirm that Ms. Benjamin had a warrant out of Burnett County for failure to appear?
Yes,
Did you then place her under arrest and handcuff her behind her back?
I did.
Ultimately, was she transported to the Burnett County Jail?
She was.
Did this all take place within the confines of Burnett County, Wisconsin, where the stop was located?
It did.
And the person who identified herself first as Chastity Benjamin and later as Billie Jean Benjamin, do you see that person in court here today?
I do.
Could you tell the court where she's seated and what she's wearing?
She's seated at the defense table and wearing an orange jumpsuit.
Let the record reflect that the trooper has identified Ms. Benjamin.
With that, the state would rest.
All right, Mr. White, questions?
Yes, Your Honor. Trooper Lind, just a couple questions about the name here. Can Can you confirm who first brought up the name Chastity Benjamin?
The defendant.
And is that a real person, Chastity Benjamin?
Yes.
Okay. Since this incident, did you follow up with Chastity?
I have not.
So you didn't confirm with her whether she gave consent or authorized use of her name?
I did not.
That's all I have, Your Honor.
All right, Mr. Renicky, redirect.
No redirect. The state would arrest, assuming no defense witnesses would ask for a bind over.
All right, you may step down. Thank you. Do you have any witnesses, Mr. White?
No witnesses, Your Honor. I'd like to make a brief argument if I could, though.
It's the court's discretion on whether or not you make an argument.
Yep.
But Mr. White, I'll give you the time to do so.
Thank you. Your Honor, just asked about the consent here, and notice the prosecutor did the same thing. It's the third element of this felony. Reading the facts here, I noticed that this case kind of comes out as you know, the allegations are more along the lines of an obstructing, a misdemeanor crime where a person gives a false name, which could be any made up name, compared to this felony. This felony seems specific, that a person is essentially pretending to be someone else. The officer did state today that Chastity Brown is a real person, so we know that, and then we know Billy Benjamin had criminal process by way of the warrant. I think the other elements are met, Your Honor. I just doubt that the third element is met, that they didn't ask Chastity if she consented or authorized, and it doesn't seem that they asked my client if she knew whether Chastity authorized the use of her name.
Thank you, Mr. Renicky.
Your Honor, first of all, inferences and presumptions are in favor of the state at this point, and the trooper did testify that he asked the defendant whether her uncle had the same pant size. The defendant had said she was wearing her uncle's pants, so clearly the defendant knew that she had warrants, had given a false name, and didn't have permission to use it. Later on, when confronted about the pant size not being her uncle, she changed that to her cousin's pants. And so I believe the inference is she was trying to avoid a legal process. She didn't have permission to use the name. And so we would ask that there be a bind over.
All right, thank you. It always comes down to whose pants are they? I hear that all the time, not my pants. Well, Ms. Benjamin, in a probable cause, in a preliminary hearing, it's probable cause. It was a felony probably committed and probably committed by the defendant. Well, Mr. Renicky was very correct that all inferences and presumptions go in favor of the state. I have to look at the evidence in the light most favorable to the state. And with regards to any credibility, that's for a jury to decide at a later date. And as well as the argument made by your counsel, because it could go either way. So that's a jury to weigh, not for the court. Or not for the court at this time. So based upon that, the court will find that there is probable cause to find that a felony was probably committed and probably committed by you in Burnett County. So I do find that probable cause and will bind the matter over. Information, Mr. Renicky?
We did sign and file it. It does mirror the complaint. It just was done electronically.
Proceed with an arraignment or set it for another date, Mr. White.
We could do the arraignment today.
He understands those charges and the maximum penalties.
That's correct, Your Honor. We can waive for the reading of those, enter a not guilty plea to the felony here, and all of the misdemeanors if that hasn't happened yet.
Not guilty pleas will be entered on her behalf. She is entitled to a jury trial, and she would be entitled to a speedy trial should she request one. Now, I do have that you filed a bond request, bond modification request. You are asking for a signature bond due to certain reasons. You can state those on the record. You may begin.
Thank you, Your Honor. My client's been in jail for just over a month now, a couple days over. She does have 6 kids of her own with a grandkid that's on the way. I believe she's a single mother, and while she's in custody, she doesn't have any income. She's unable to post that amount. I don't see her financial situation getting any better. I think if anything, it's going to get worse. And if she's unable to get a bond modification, she's likely to remain in custody until this case is tried or goes to sentencing. And those are the reasons why I think we filed a letter from Ms. Benjamin herself as part of the motion. It's basically restating those same reasons.
All right, I have received that letter and reviewed it along with your motion. Mr. Renicky.
Your Honor, the defendant has missed multiple court hearings. The 21 CM 150 file is still open. It's more or less tracking with this case, but that's been open for approximately 3 years plus because of multiple missed court hearings. We've actually had missed court hearings in this open file, and I believe that there may be a new referral on a felony bail jumping, although I'm not familiar with that particularly, although I understand that there may be a new felony bail jump referral. We've got to finish these cases at some point. It's never convenient to be in custody. It's never convenient to be convicted of a crime, but those are sort of the drawbacks of committing crimes and not taking care of business when you're supposed to. She's not a resident of this state. She doesn't have good contacts with this state, and she has a bad track record of showing up. So we would ask that the bond modification be denied.
All right, thank you. Those arguments are pretty strong, Mr. White, because we have had this open case, 2021 case, for a significant amount of time, and $1,000 or more is not enough to assure her appearance. That's what bail is for, Ms. Benjamin, to assure your appearance, and having a large amount of bail was not enough. $1,000 was not enough. $1,200 was not enough to assure your appearance. I need to make sure that you're going to come to court. You haven't proven that, especially with your 21 case, and now with your 24 case, you didn't come either, and my guess is because of you knew that you had a warrant in your 21 case. I don't know.
I also
Just
was
my
in
guess.
prison. So I was in prison within the year after the 21.
I know. Well, the year after, but remember, because I have a good memory of an elephant. See, I remember when you had your 21 case and you were coming, and I remember your attorney, and we were all set to take your plea prior to you going to prison. You were in custody, and then you were out of custody. And I said it for when you'd be out of custody, because you begged me and you said, Judge, I'm going to come back. I promise you, I'm going to be there. I'm going to be there. And I said it, you weren't there. And then sometime later, that's when you went to prison. So I have a good memory, and you can't fool me. So I need to assure your appearance, and I need to assure that these cases are going to be resolved. So either you post the cash, or we continue to get these matters resolved, and we can do so in a quick fashion. You do have that right. So talk to your attorney, and we'll see what we need to do. But right now we can set a status conference so he can get the discovery, and then you guys can talk and probably figure it out. We had the 21 case figured out, and quite honestly, I think you were gonna get it done, and it was going to be close and run probably with your prison case, I think. But now that's done and over. And so now we have this other case, and so your attorney has to work with the state to get what's called a global offer, probably. Mr. White, let's get you back. I know I don't have you written down for coming back anytime soon. So let's try and get you back sometime soon so that you can talk with Ms. Benjamin, you can talk with the state, and we can get this going. I don't think that Mr. Schmidt has a conflict. I didn't remember with my memory, and I don't have you on his list. So can you come January 3rd, Mr. White?
I can in the afternoon.
In the afternoon. Well, that's the time I'm booked. So how about January 10th in the morning? I have between 9 and 10.
I'm wide open, Your Honor. I could
Or
do.
January 9th, I have for statuses. But if you want a potential plea, if you're thinking that it might go that way, if you look at discovery and whatnot, she wants to see if she can resolve this, I can set it for a potential plea on the 10th, and I would have enough time to do so.
That sounds good, Your Honor, if we could take 10 o'clock.
Well, I would have to have 9:30.
Or 9:30, sure.
9:30, I will schedule you 9:30, January 10th. All right, we'll see you then. We are.
Thank you. Michael Abruzzi.
That's me. How you doing?
Mr. Abruzzi, it looks like you have a new criminal complaint here that says that you did, pardon me, on or about December 13 in the village of Hebron in Licking County, recklessly violate the terms of a protection order issued or a consent agreement, either under civil or criminal law. Under 29-19-27, recklessly violating a protection order is a misdemeanor of the first degree, would carry up to 6 months in jail and up to a $1,000 fine if you were convicted of that. You understand what that charge is and what the maximum penalty could be on that, Mr. Abruzzi?
I do understand what the maximum penalty is based on what you had just told me. I'm still a little unsure about the actual charge itself. It was kind of news to me.
Well, for our purposes today, all we want to kind of take a look at is whether we understand what that charge is. It may be dismissed. You could be found not guilty. All manner of things can happen with that charge, but what we want to do today is just make sure that we're all on the same page about what it is that they say you did that brought you to court this time. So that, with that in mind, you understand what the charge is. I'm not asking you if you agree with it.
No, because it would be like being within 500 feet of a protected person.
I'm assuming that there's probably something like that in there. I'm not sure what the exact logistics are, but yeah, it would be violating a current order that you have against you, which you have received and is part of your knowledge at that point.
Yes, I do get that.
So with that in mind, there are a couple things you can do. We can continue this so you can talk with a lawyer before the arraignment, or if you want to enter a plea of guilty, not guilty, or no contest, we can talk about doing that. Any thoughts about how you'd like to proceed with that today?
Ooh, that's a tough one for me. I have never really been in trouble or even been to court before, so
Okay.
I
Why
don't
don't
know
we
what
do
to
this?
expect.
Since it's a little unclear on your end here as to a couple things, why don't we enter a plea of not guilty? Did you get a copy of this paperwork?
Yes, I did get a copy of it, and I was trying to shoot for like an OR.
Okay, why don't we do that? Let's enter a plea of not guilty. That way you're not waiving anything. It'll give you time to either hire a lawyer or fill out an application for a public defender if you need one. We can do that. Let's do that. And let's talk about right now about setting bail. Prosecutor's office has put some recommendations in the file here that they are recommending a $2,500 cash or surety bond and a no contact order with. They are indicating that they believe that there are multiple acts that violated the civil protection order on the evening in question, and they are concerned for Ms. Hartshorn's safety on that. So with that in mind, what would you like to tell me about setting bail on this?
I have no idea. I'm kind of confused, honestly. Like I said, I've never done any of this before. I'm not even quite sure what it all means. Now, will I be able to do like an OR so I can get back to work?
Hang on one second here. Where you work?
Okay. I work at Michael's Pizzeria over in Jacksontown. I just started opening up over there.
Mr. Abruzzi, let me just say this.
Yes, sir.
I hate to see you lose your job, but I also hate to see you with the opportunity to violate the temporary protection order or the civil protection order again, because it looks to me like the facts are pretty straightforward that a police officer observed you following her in a car, observed the text messages, and you act like you don't really know what's going on there. And it sounds to me like that it's a pretty straightforward case based on what the officer and the young lady indicated. And if you aren't capable of staying away from her, anything I tell you is gonna you're probably not gonna pay attention to it. So I guess what I'm saying here is that fill out the paperwork for a public defender, talk to that person about the issue of bond in your job. But I think that I can't in good conscience just let you walk out of there having just gotten that paperwork back in November signed, served on you. I can't trust the fact that you'll stay away from her. I got a lot of problem with that, looking at that fact pattern. So
I do have a question. Now, what if she is getting a hold of me? Because a lot of the time she is
something that you got to take up with your lawyer, but the facts don't look like that. It really doesn't look like that. But I think you need to get a lawyer. You can have your lawyer request a bond review very quickly, and we can take a look at it with some more information. But for right now, I'm going to, pardon me, hold that bond at $2,500. No contact with Ashley Hartshorn, and if you make bond, I'm going to indicate that GPS bracelet would be part of the bond.
That's fine.
So that we know where you are and that you're not close to where she is. Talk to your lawyer, fill out the paperwork, got you down for a not guilty. You'll get a date very quickly here that'll come to the jail or to your house from the clerk's office telling you what it's set for. And
so what is the soonest I can get out of here with the bond? Because I'm just still trying to open up at my job. Trying not to get fired.
Got any KRPs? L's?
it's a $5,000 cash or surety bond with no contact with Ms. Hartshorn and the GPS monitoring. Make sure you fill out an application for a public defender if you need one.
Okay.
If not, hire a lawyer. That'll be all for today.
All right, thank you.
Jones. Nehemiah Denise Jones. 19B 1367339 and C and A. Where is she at?
She's here, Judge. Good morning, Judge. Mazengate, appearing on behalf of.
I sure hope she's come here with some money. This is ridiculous. It's a borderline ridiculous. Your name?
Nehemiah.
You see all these red stamps on here? You see all these red stamps? That's when you stood out there and thumbed your nose at the court. You better get going, young lady. It's been going on since 2019.
Correct, Judge.
I'd like to go back to 2019. Be 5 years younger. Huh?
You don't look it, Judge. You don't look any older.
Give me a break. I hope she has some money.
Judge, we're just asking.
Counsel, I hope she has some money because my patience is wearing thin.
She just had a baby, Judge. She's got another minor child. She's currently not working because she's got to care for the child.
She hasn't been paid. She hasn't paid on these tickets in 5 years.
Understood, Judge.
5 years. 5 years. You could pick up a pop can a day. Over the course of 5 years, you'd have had the money. Right? Am I right or wrong? If you're going to be a mother, I'm serious. Act like it.
Judge, we're just asking for a small.
I know, but she's had 5 years.
Understood, Judge. I've talked to her about that. She understands that. At the time, she was living with her mother, and her mother moved to Arizona, so they never, and all the notices were going to a different.
How old is
address.
she?
How old are you now?
I know, she forgot about it
She's
or didn't
23,
know, or
Judge.
we were hiding the notices, right? How old is she?
23.
We filed a tax garnishment, apparently. It looks like it's stamped all over here. So we're garnishing your taxes. We never did that before, but honestly, we get a bit tired of people doing this, acting like they don't have any obligations. January 15th, right, Lisa? This is, actually, I'm gonna set a jury trial or bench trial too. I cannot continue to do this. I mean, this has been going on, like I said, for 5 years. I'll give her January 25th at what time, but I'm also setting a jury or bench trial.
For that same day, Judge?
No,
January 15th at 10:30. And then do you want jury or bench?
it's up to them.
Did you want a jury trial or bench?
I don't know what either of those mean.
You talk to your lawyer further. Hang on. We're gonna set that before you go. And I'll give you January 15th as your new pretrial date, but I'm gonna end this case sometime before I leave this bench, okay? All right, good enough. Wish you well.
Thank you.
You're gonna come back in front of me, so don't leave. Good luck.
Just have a seat outside in the hallway and I'll.
Actually, I'm just setting it for jury. Just set it for jury, Lisa. The last Friday in January or first Friday in February.
January
Calling Miss,
31st at 8:30.
Call in Ms. Foley Carter.
Judge, if that's gonna be on my docket, I've got a preliminary exam scheduled in Adrian on the 31st
At what time?
at 9 o'clock.
Do you think this is gonna go?
At this point, Judge, I couldn't tell you.
Judge, in January, it switches over, so it'll be a different attorney.
Okay, January 31 at 8:30. Is that a good jury trial date for you, Ms. Foley Carter? I'm setting this for January 31 at 8:30. And I heard what you said, but the new lawyer will handle it, okay?
Okay.
I don't know how she's gonna dig herself out of this hole. How's she supporting herself? Is this the father of the children?
Yeah.
Well, she had a job, but when she got.
I just asked her, I can't have people talking across the,
Yes, that's the father of my kids, Your Honor.
all right, we'll see here on the 15th. Do the best you can, but you don't get off to a good start with me when you play this game. And you've been playing a game with us for 5 years. Good luck. Stephen William Church, 24B147140M.
Good morning, Judge. Mazen Gates, appearing on behalf of Mr. Church. There's a date and time set for sentencing.
Your name, sir?
Stephen William Church.
I'm kind of impressed. You got as many retail fraud cases as I've ever seen from one defendant. You know, I would have thought you'd have to live till you're 128 to get to this. You got 14 retail fraud convictions. You don't want to work or what?
I do work now. I went to prison and changed my life.
Well, shocking. Shocking that you went to prison. After only 14 of them, plus some other ordinance violation out of the 19th District Court that's not identified, plus a domestic. And now he's pled guilty to telephone harassment. And I am ready to sentence him, and I'm not the least bit amused. That is all I will say. You can go ahead and tell me, counsel, whether or not everything in the report is
It's actually
accurate.
Judge.
Anything you would like to say on his behalf?
Well, with regard to the report, Judge, we have no omissions, corrections, or deletions. We just have just a note with regard to the third item, the court work program. Mr. Church lives over an hour away. So if there could be accommodations made that with regard to him being able to satisfy that requirement without having him drive all the way here, we asked the court to.
Say that again?
because he lives over an hour away.
Yeah.
So if he's gonna attend the court work program, he's gonna have to drive over an hour to get here
Okay.
in order to make it. And I know they, sometimes they start early at, I believe, 7 or 8 o'clock. So we'd ask the court just to take that into consideration. But moving forward, Judge, with regard to Mr. Church, he is 39 years old. He's been employed with Waterford Collision as a tow truck driver for the last 5 years. Although, as you mentioned, he does have a significant criminal record. He did do some time back in 2018. He did get out, and since getting out of jail, Judge, he's had steady employment. He's had no other contact with the law enforcement or the legal system other than this pending case. He does have 3 children, 2 of whom are minors, and he knows that he needs to be a good role model for these children, Judge. And the complaint.
He's not gonna be able to see him if he keeps talking to his ex-wife like this.
Well, that was the issue, Judge. With regard to the incident between himself and the complaining witness, he understands that this is not the proper way to handle this. And this is ultimately boils down to a custody issue. And I did inform him that the proper venue for those issues would be family court, Judge. He does understand that. And I know that he wants to address the court as well, Judge. Right, sir?
Yes.
I can't wait to hear this. You might save yourself. What do you want to tell me?
I've been in mental health since I got out of prison. This has been going on for 2 years. It got better and then it got worse. I should have kept my words to myself.
What does that mean?
I shouldn't have said anything to her.
You should have had better self-control.
Yes, ultimately better self-control. That's something that I still need to work on. And I completely understand that I am responsible for my actions. And I'm willing to do whatever I can to put this behind me and move forward.
I don't like people threatening people. We have far too much violence in this country. I don't know why everybody's so angry. I really don't. I have some theories. I have some ideas. Never thought I'd see it get like this. I don't care what it's about. I really don't. No idea why people are so angry. I guess some of them never stopped to think we're just not here that long to begin with. I mean, I guess if we got to come back here 28 times and live until we're 96 each time, maybe you could spend a few hours or few years being angry. We're not here that long. I don't get it. I don't understand it. I never have. It's gotten worse. I don't know how it's going to stop, where it's going to stop, but people assaulting people, shooting people, threatening to kill them. I don't understand it. And you got a big problem with me right now. And somebody's going to say, some defense lawyer or somebody, oh boy, he only had 1 domestic violence. Yeah, I know, but this is the totality of your criminal involvement. And somebody else is going to say, well, he's got mental health issues. I get it. I get it. It's been pretty apparent, I think, that you've had some issues going on now for 20 years. This is your criminal history started in 2004. And it's just continued. And this stuff about mother effers ending up dead and all that. We're not playing video games here. These are not video games. He hasn't been able to see his kids lately, right?
I do see my other 2 kids. I just haven't seen him since.
This is your number. The numbers end with 0556, right?
Yes.
It's just such ugly talk. I guess some people just don't think words have meaning. Nobody should live in this country in fear. Shouldn't have to do it. I'd like to think nobody should have to live anywhere in any country in fear. When your ex or the father of your child or children starts making these kind of comments and threats, I don't know how anybody can feel comfortable. Obviously, the prison time didn't help you think about where you were going with your life. I'm telling you, I just don't understand it. I weep for this country in a lot of ways. "21 months probation." Have I let everybody finish?
Yes.
21 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. Change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. I fully recognize that this case, there's a presumption of probation. I get all that. I'm still looking at somebody that has roughly 16, 17 convictions, including a domestic, including this. I'm going to order you have no cons. You're not to possess firearms. You're not to possess dangerous weapons. You're to attend an anger management program with 12-week follow-up. You're to continue your mental health treatment with CNS. You're to pay fines. And he did not spend any time in jail on this at all, right? 200 fines, 100 costs, 75 victims' rights, $50 justice assessment, 4.25, screening fees 60 for 485, probation fees are 420 for 905. I am correct, counsel?
If you'd like, Judge, I can do the numbers.
You did not have any, you didn't spend any time in jail on this,
No,
right?
I didn't. I was issued a ticket and I came to court.
21 days jail. You're going to serve 15 now. You're going to serve 6 days of community service in lieu of jail, and I'll give you until February the 20th of 25 to serve that. You owe the court 905. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal. 14 days to apply for a court-appointed lawyer for purposes of appeal. I will let you pay these fines and costs as follows. $40 weekly. I will start this because I realize you'll be in custody for a while. I will not start this until March the 14th. If you don't have any money on any of your due dates, you call the court. We'll go on Zoom, or you can come in here and I will give you an extension. So either way, what's better is your choice. But you are in custody now. And I'm just, I'm telling you, you're going to stop committing criminal acts or you're going to have a big problem. Have a seat. Right over there in the jury box.
Judge, if I may, just with regard to the counseling with CNS.
Yes.
He said through his employment, he did get insurance. So he's actually going to a private therapist.
Come here. I'll just say mental health treatment as long as it's approved by probation. Okay, Mr. Gay?
Okay.
You understand that? So it doesn't have to be with CNS.
Okay.
I'll just say continue with treatment at facility approved by probation. Good luck.
Thank you, Judge.
Sir, do you have a case in here? Do you have a case in here? Oh, Gerald, how are you? Jeez. How's it going? Come on back here.
We have one more, James Jones. He called, he said he was in the hospital.
Well, adjourn.
I asked for proof.
Yeah.
I didn't receive proof yet, so I think Mr. Gates is gonna give him a call.
I'm gonna give them, Okay, I'm gonna give him a call. If he
Okay,
can
sounds
submit
good.
proof,
Sounds
we'll
good.
bring it in.
Not in trouble. Come on in. Come on in. Nice to see you, man.